Beautiful suit. I'm sure you noticed that.
We've all heard of crazy things like this before.
Yeah. Oh my gosh, what are you saying?
But if you don't do that, you might lose on appeal. I'm Mark Breyer.
I'm Alexis Breyer.
Who are we?
The husband and wife law team.
Here's the thing, we actually go to trial. We fight for people. So we got this Abby Zwerner trial, and a lot of people have asked questions, and so it's an interesting one because it's a civil case. So this is actually the lawsuit by Abby Zwerner, who's a teacher, and she was shot by a 6-year-old student. We have not seen this trial.
I only knew the ultimate ending. I didn't watch actually any of the
See
trial.
what happens when people are on social media, and some of us are out here working,
Yes.
and some of us not. So I didn't know
Yeah.
anything about it. So we're gonna do this together. You ready?
All right, let's
So
go.
we got opening statement of the plaintiffs. For people who don't know, this is the person who's suing, the person who was hurt. She was shot in the hand. She's lost permanent function of her hand. There's a bullet lodged in her chest, 6 surgeries, weeks in the hospital. And she's suing for money damages because that's all you can do in the civil system. You can't put someone in jail. That's coming later. It's going to be another trial, criminal trial, but all you can do is sue for money. And people who get mad at that, well, you can't go back in time, and you want justice, and people shouldn't get away with it just because they can't undo the harm they've caused. So should we hit play and see what's up?
Yeah, let's go.
Good morning, members of the jury. In every school, there are spoken and unspoken promises that teachers trust administrators to keep. One of those promises is that when teachers sound an alarm that something is wrong, administrators will answer. In this case, on January 6, 2023, those promises were broken. And those promises were not broken by chance or confusion, but through a series of deliberate decisions that were made inside Rich Neck Elementary School.
First, beautiful suit. I'm sure you noticed that. Beautiful pastel blue. I love it. I think she is doing a fantastic job. I love how she's talking about the rules. I love how she's talking about that there was intentionality, that it could have been avoided, and I think she's doing a really good job.
What people would be surprised to know is, and I do not know this lawyer, but she practiced that start. She probably focus grouped that start. She talked to other lawyers about that start. The power of primacy, right? The first thing you hear. And what did she make it about? Did she make it about her client who got hurt? No. The jury doesn't deeply care about her client. The jury deeply cares about the safety of the community.
Right.
And she starts out by focusing that this was not a one-time mistake.
Right.
It wasn't an accident. They knew what they were doing. They made choices that led to this on a much bigger scale than that one moment. So let's see where we go.
So do you think she's doing a great job?
To the degree I can judge the first minute, great first minute, but now she's got to back it up.
True.
Anyone can say that this was a failure beyond that moment. You got to back it up. But do I like the start? Yeah, I think the start focuses on what someone who's hurt like this should focus on. Great job.
Went to Dr. Parker on that day, the 4 different staff members and teachers with their concerns that JT has a gun. You're going to hear that it was a 6-year-old child. Who would think a 6-year-old is going to bring a gun to school and shoot their teacher? Members of the jury, it's Dr. Parker's job to believe that that is possible. It's her job to investigate it and to get to the very bottom of it.
I think she's doing a really good job. I mean, she's talking about the rules. She's focusing on the safety. She's focusing on the responsibility of the principal, assistant principal to others. It's crazy that a 6-year-old would bring a gun to school. And I do understand how she could dismiss it, but you can't at this day and age ever dismiss that.
First of all, we've all heard of crazy things like this before.
Yeah.
Presumably they're going to go into this trial as part of the training. But another piece I just want to say is she didn't focus on her client in those clips, right? She focused on something that was preventable and choices that were made. So we don't get to see the defendant's opening. Maybe we won't see it, but here we go. Who's on trial? Who's on the stand, I mean?
Amy Kovac, she's a plaintiff witness. The first voice you're going to hear from the female voice that's questioning, that's the plaintiff side, and then cross-examination is the male voice outline.
Did you feel any assurances after you searched JT's backpack?
No. Again, he was acting so weird.
And did you tell Dr. Parker that?
Yes. Like, he was curled up. He likes to talk. So usually, he'd be talking or running around. That bag, we carry it around, His mom usually brings it in that week. She was bringing it in, getting settled. That was a week without, mom attending school or dad attending school with him.
So when you're talking to her, do you feel that you explained to Dr. Parker that you feel this is a serious threat?
I thought so. At that point, I heard that gunshot, and instinctively, I walked into that room. As I come in the door, Abby's on this side. I see blood on her leg, so I knew she was hit. On this side, I see Jen open the door, the kids screaming and running out. I felt like I had a bubble of God around me, and I walked straight to him. He was standing there with his legs kind of spread open, arms crossed and cocky. And when I got to him, I didn't say anything. I took his wrist because I knew he shot with his left hand. I walked to Abby's desk where her phone was. I put him in between my legs, put my arms around him. I picked up the phone to call 911. I said, "This is Rich Neck. A teacher's been shot. I have the shooter. Send help."
I'm a little confused. It seems like they did search the backpack.
I'm sure we're going to find out more about that. I agree.
Yeah, because I'm like, how did you just not take the gun if you searched the backpack?
I think we'll learn more as trial goes on. Remember, because we only we haven't heard any of the defense opening.
Yeah.
You know, it was striking to me hearing her say, "I have the shooter." It's a 6-year-old.
I know.
I have the shooter.
And that he was standing cocky.
Right,
It's like
but
a 6-year-old little boy.
But we're going to see this because we're about to see the cross-examination of this witness. That's bad for the plaintiff. A 6-year-old who could shoot a teacher and just stand there like, yeah, I'm bad, right? If you focus on the 6-year-old, then you're not focusing on where the plaintiff wants it right now, which is the school's choices and how we got here.
You didn't follow up to confirm the basis of their
I tried to follow up by getting that bag to see what was in it and talk to him and see what was going on.
So your focus was to go after that bag, right?
Yes, and him.
And
See what was going on.
Right. You had just been warned that this small child might have a firearm in an elementary school classroom. So you took immediate action, right?
Correct.
And you went directly to him,
Correct.
right? And you sit down next to him, right?
Correct.
And you're within at least arm's reach, right?
Yes, but
You sat right beside him.
he was here, and I sat next to him. He was balled up. I wanted him to talk to see exactly what was going on.
And the backpack, he wasn't holding it.
No, it was on the side, but he had his body close to it.
So the backpack was next to him,
Correct.
right? And you were next to him as well.
Correct.
And you're the third in command of that school, correct?
Not really, only when they're absent. I am not an administrator. I am a teacher with a specialized degree and certification in reading.
You're also not a 6-year-old child.
No, not at this time.
No, you've confiscated contraband from children before.
No.
Never. Never as a teacher have you ever confiscated any material from a student.
I mean, papers, homework, something out of their book bag, like money if the parents sent it in, picture day.
Don't elementary school teachers, aren't they in and out of school bags all the time?
Correct.
Right? That's pretty routine.
Again, we did not, knowing JT, his behavior, his actions, and the other children being in the room, I was not going to cause hysteria. I did what I did. I sat there trying to help him based on that relationship, and then I went and reported. And I can't help what somebody else did not do.
Well, what do you think of cross-examination of the alleged third in command?
I do think she was pretty defensive, and I can understand why. It's hard to be cross-examined. A good trial attorney is going to make you feel on the defense.
Did you think he was doing well?
I thought he was doing a pretty good job with her. He wasn't attacking. He was kind of talking to her. He could have maybe been a little bit nicer knowing she's an elementary school teacher. I think people, might have looked at her as not a professional person who's going to be on the stand.
Definitely not a professional witness.
Yeah, she's not a professional witness. She's a teacher. It's a traumatic event. But I think he did a pretty good job, and I definitely am, in my mind, thinking if you thought in any way there was anything dangerous in that backpack, why didn't you simply take it away? I do get that she reported it, and that makes sense. And I do think some of these things are hindsight is 2020, and we're only seeing a small
But if
clip.
it's hindsight 2020 for for her.
It's for the principal
For
too.
the assistant principal
But the
too.
assistant principal is going to be held a lot more to a higher standard because this is just a teacher, if
Unless
you
the
will.
other two are gone. I do think that what people don't consider on cross, which is exactly what you pointed out, is you can come at everybody. You can be much more effective on paper by coming at everyone. But there's a jury and they're judging and they're watching, are you being fair to this witness? So a professional witness who's super full of themselves and they're ready to fight you, you can take it to them. And the jury is going to usually give you more leeway because it's a fair fight. Would not have been a fair fight. I thought he was well within a reasonable range. And I thought he did a good job making his points on cross-examination. It would have been interesting if he had backed off a little bit to see if she talked her way into more trouble. But I have zero criticism. I thought it was a really good cross. But he, in theory, just to point out what I'm saying, in theory, he could have said, so it's your position that you couldn't have reasonably just opened up the backpack and looked. People would say, never ask a question you don't know the answer to, but sometimes, no matter how they answer, it looks ridiculous. So far, the lawyering we've seen, which has not been true of the few cases so far, and we're only a few minutes in, the lawyering we've seen has been good lawyering.
Why would they ask, you're not a 6-year-old boy, right? Why would they ask that?
I think he's just trying to make the point that you got a 6-year-old here, you're an adult, and you don't just trust a 6-year-old. Open up the damn backpack and look, do the same thing that you're saying we didn't do. You were right there. You were in the classroom, 6-year-old next to you, backpack next to him, grab the damn backpack, open it up and look. Now you're here defending a lawsuit against our school for someone not checking a backpack who wasn't even in the room. And so he's trying to make that point. It's a tougher job than you would think because you don't know how it's gonna play in front of the jury. You don't know what this witness is gonna do. There's some pieces that I don't know. It's very easy to sit here.
I think you're a point, though, that he's trying to show that she had the same knowledge, the same information, and she was right there that the assistant principal had.
The defense would argue more because he even said it. You were with the kid. You were in the arm reach of the kid. The backpack was next to him. That's where the gun would be.
You know the kid better.
And
You're
maybe he
seeing
did
him.
this, but he could have said, so when you know there's money for pictures in a school bag, you'll grab it. But when you think there might be a gun that could harm someone you love, you don't grab it.
Because
So
the truth is, she didn't think there was a gun in there and he was about to shoot the teacher.
Because that's two steps. Does she really think there's a gun?
Yes.
Does she really think he's going to use it?
Right.
It's a crazy case.
Good afternoon.
Good afternoon.
Can you go ahead and introduce yourself to the jury?
So this is direct examination. This is the plaintiff's, the guy on her team.
Hi, I'm Hannah Zwerner. I'm Abby's twin sister.
And during those times growing up early in life, did the three of you grow a bond together where you could understand who Abby is as a person and how she changed through the years?
Yeah, I mean, we've built a lifetime of memories together. We're very close. I think she's even more than my best friend. She's my sister.
When you spend time with Abby and before this time, I'm going to show you a video. You see that picture of her, or video, I should say?
Yeah.
What does that remind you of your sister before January 6, 2023?
Full of light and spark and just so outgoing and just silly.
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 I'm going to change gears and talk about after January 6th.
Okay.
You said that was silly, full of light. Can you tell us about that light in Abby today?
It's an objectionable
It's
question.
still there. It is very dimmed. She's just not the person that she was. I feel like she's kind of lost her sense of direction in a way. She doesn't want to go out anymore. I don't talk to her as much as we used to. We talked about the unspoken twin language, and I don't know what she's thinking all the time. And yeah, I think that she had a lot to be excited about, and she doesn't anymore. And so that light has kind of dimmed.
I thought the sister did a really good job. She didn't make it so bad, like her life is entirely over, but she did say this has had a really big impact and it has made her different. Juries like to know that your whole life is not in complete crumbles and that you are doing everything you can to get back to a good spot. And I think she did a good job in that short clip that we saw, saying it's had a massive impact. She's still trying. I like the phrase she said. She used to have a light, it's just dimmed now. So I imagine she went into a lot more detail. So I thought she did a good job.
So this is a lay witness. It's a before and after witness, and it's a witness that's only about damages. She is not there to do anything other than to get the jury to understand the impact, because they have to use dollars for something dollars can't fix. Why? Because we don't let people get off the hook for doing negligent things just because they can't fix it. So there's got to be some way that we measure it with dollars, and that's her job. Her job is to get the jury to understand the impact. I hope later on, and I suspect, that there were more details. Here are specific things she no longer does. Here are things she still does, but not as well. Here are conversations we now have that we never would have had. I think that when you speak generally as a before and after witness, it has value, but when you can get specific, so the jury can go, okay, I know you're her sister, but this sounds real to me.
You did mention the objectionable question.
Yeah. First of all, most people are not going to object when a sister's on the stand. And there was nothing wrong with the question, and I would potentially overrule the objection. It's silly, but he was leading her, right? He didn't just say, tell us more about the impact on your sister. Tell us what happened to that light is arguably a leading question. It's a stupid objection. There's nothing wrong with asking the question. He's trying to move it along. If they object and it's sustained, he'll just say, tell us about your sister. And the witness already knows what you were trying to ask. Nothing wrong with the question. Some lawyers, to throw you off your game during emotional testimony, would find any reason to object. In theory, they could object to it. It would have been silly, but they might have done it and it might have been sustained. This is an expert witness that we're about to hear from.
My name is Dr. Clarence Watson. Clarence Watson.
And you're a doctor in what?
Psychiatry, forensic psychiatry.
And doctor, you're here today because at some point we had asked you to evaluate our client, Miss Abigail Zwerner. Is that correct?
That is correct.
And you, as a result of that evaluation, have come to some findings as it relates to her psychiatric condition. Is that correct?
That is correct, yes.
Dr. Watson, I'm going to ask you about the evaluation now. And as we go through it, I may be asking you for your findings or your opinions as we go through them. Will you agree only to offer those if you hold them within a reasonable degree of medical certainty?
Yes.
I just want to explain what's going on. This is an expert witness. He was hired by the lawyers to offer testimony on things juries can't do without the help of experts. So they're trying to bring in this expert to do that. That little phrase you just heard, please only offer opinions if you believe that to a reasonable degree of psychiatric probability or psychological probability, whatever he said. It's necessary for the court in many states, in most states. Experts are not allowed to just give random opinions. They have to hold them in effect more likely than not. So that was like one of these things that the jury has no idea what you're talking about. But if you don't do that, you might lose on appeal. That, depending on the state, can be a critical question.
Your final conclusions and opinions, did you have enough materials and information for you to make that clinical finding?
Yes.
That diagnosis?
Yes.
And can you share with us first what the diagnosis is, and then we'll break that down and explain how and why we got there?
Yes. The diagnosis is post-traumatic stress disorder. Yes, so the DSM, the criteria for post-traumatic stress disorder, requires that there is exposure. A person is exposed to actual or threatened death, serious injury, or sexual violence.
And in your evaluation of Ms. Zwerner, obviously we've talked about the facts of this case, but was there any reporting from her to you about her perceived risk of death?
Yes.
Can you tell us about that?
Well, she believed that she was dying, that someone was trying to kill her, and that they had successfully made that attempt, and she was attempting to survive, and she was bleeding and had difficulty breathing and panicking, believing that that individual was following her and was going to finish the job.
And in your review of her evaluation, does that check the box, so to speak, as it relates to the traumatic event?
Absolutely. It's almost, that's sort of a classic.
As an expert witness, I feel like it should be oh, you're going to do a great job. You're an expert witness. You get paid for this. You might probably have been doing this for a long time, but we know that's not always the case. But
No, that is not.
That is not always the case for expert witnesses. It's like, oh my gosh, what are you saying? You've never said that before. I thought he did a good job. I do think when it comes to objective injuries or something that makes sense and is not subjective, I think it gives a lot of more credibility to an expert witness. So I think if somebody's shot, even if it is by a little kid, like if you're shot, I think it is believable that you're
bullet doesn't care how old the shooter was.
It's very believable that you are going to have some PTSD and that your light is going to be dimmed from what her sister said. So I thought he came across credible, and I do think that her PTSD is believable. I think the question ultimately that the jury is going to have to decide is, besides the part about if the assistant principal is responsible, but also how much of an impact has this had on her life?
This expert goes only to damages, how much money should be awarded. So many of these PhDs who testify, first you have to be smart enough to get a PhD. That makes you smarter than most of us. Then you have to be willing to go to court and take on lawyers in a courtroom. Many people who want to do that in that setting are sure they're the smartest person in the room. They come across that way. Experts are made to me and cross. I don't know how he did because we didn't see the cross, but he sure came across as down to earth and likable there. He seemed like a great witness, but if you get shredded on cross, it doesn't matter.
My name is Abigail Zwerner. And Abby, how are you feeling right now?
I think nervous is a big one. Nervous, anxious, a lot.
Just tell the jury, how long were you a teacher?
About 2.5 years.
How did you enjoy teaching?
I liked it. I do remember it was stressful a lot of times. Being a new teacher, a lot of new experiences, a lot of ups and downs I remember. Yeah.
So tell the jury, when on that day did you first hear about JT might have a gun?
It was before recess.
And do you remember who told you that?
Amy Kovac.
And if we can zoom in on the orange sheets that are behind your head, do you see those?
She has to worry about them
Yes,
blaming
they do.
her.
Can you tell the jury
Amy Kovac or her?
No, blaming her.
Yeah.
Why didn't you go check? It's your kid.
That would be our
Just a risk.
handbook, our school's handbook. Our, I believe it was titled the Crisis Management Plan.
A lot of lawyers do ask the question. I've seen it asked, like, how are you feeling? But I feel like it's usually so obvious. I'm not saying it's right or wrong, but often I'm just like, it speaks for itself.
documents in front of you?
Yes.
Do you recognize those two documents?
Yes.
And what are those two documents in front of you?
On the left and the right side, it looks like the three. I don't know how to explain it. It's like the combined on the one sheet of paper that I had on the orange sheet of
see
paper,
the
like the level
injuries
1
to her hand.
behaviors, and then on the right side of the screen, level 2 and then level 3 behaviors. I had that all on one sheet of paper, the orange paper on the wall.
And in the student behaviors, is there a possession of a weapon listed?
Yes.
Possession of a weapon.
And then next steps, that's for the administrator to do, correct? That was your understanding?
That is a leading question. You're supposed to say, what is that? But she's afraid her client won't
Next
say the right
steps.
thing.
And
I feel like as a trial attorney, you can ask questions like that until somebody says objection.
Even if they object, the witness already knows what you're going to ask. So
Right.
sometimes if your witness is stuck, ask a leading question because they're going to object, potentially. They object, the jury may think they're trying to hide something, and meanwhile, you just told the witness what you want them to talk about. So now if you lead too much, you look like you don't trust the witness. But this is a really nervous witness.
And you could get in trouble with the judge. You don't want to
Yeah,
do
well,
that.
whatever. Yeah. And I want to win the case, and I'm going to do it ethically, honorably, professionally.
Yes.
But if I have a witness like this,
Yeah.
let's lead her to help her understand,
Yeah.
but not so much that it looks like we don't trust her to answer the questions. That was a good leading question because if they object, she knows, and you can feel from here how nervous she is.
And
What
even the jury
did you
knows.
see?
Yeah, of course.
right before you were shot that day on January 6, 2023?
The moment went by very fast. I remember Dr. Watson touched on it briefly earlier. The look on the student's face is a large memory that I have. I do remember it was like a very blank look, but it wasn't a blank look at all on his face.
And is that why you lifted your hand? Did you know what was about to happen?
Yes. Yep.
And what is the last thing you remember that day at the school?
Obvious, I thought I was dying. I thought I had died. I thought I was either on my way to heaven or in heaven, but then it all got black, and so I then thought I wasn't going there. And then my next memory is I see two coworkers around me, and I process that I'm hurt, and they're putting pressure on where I'm hurt.
You can feel her thinking through her mind. I obviously want to hear more. If you're going to ask for money from a jury, like, you want to really hear more. So this is just a short clip. But she's a young girl. She's a teacher, which is a very empathetic position, loving, nurturing, especially for probably kindergarteners. I feel like you can feel her depth of emotion for what she's been through.
I agree, and I would add what the lawyer did by allowing her to get there. Stayed back, didn't try to help her client. Even though it's hard to watch, it's because it's so raw and real. And allow the client their chance to express themselves. That's why you don't want to lead. In this setting, you don't want to go then this, then this, then this, which some lawyers do. Her lawyer is giving her the space, and you can feel exactly what you said. You feel, yeah, you want to know more, but how much more do you need to know?
I also think by letting her talk and process it, that's the time that the jury gets to build that relationship with her and gets to really think, is this a person that I really believe? Do I feel for her? Because ultimately, if the jury doesn't like the plaintiff, they're not finding for her, no matter what, or him.
No one's trying to give millions of dollars to someone they don't like or trust.
Yeah.
Generally
So
speaking.
they gotta love her if they're gonna find for her.
At least connect.
I was going to ask too, real quick, if
I wish the people on camera could see you now, Sean, because they would understand the wrong people are on this side of the camera.
Yes.
This is often the man that's helping us put all this together, but today he looks particularly handsome.
These are tattoos that our
It's our
team put
tattoo,
on.
not just any tattoos. Look at that. Look at the good-looking girl and the not-so-good-looking guy tattooed all over this man's face.
committed.
How many of you out there,
Commitment.
when are we going to get more of these? We need more people with more face tattoos of the husband and wife law team.
We do have extra tattoos if any of you guys want them.
Or just, go to a tattoo parlor and send it to us. Don't do that.
That'd
Don't
be a
do that.
little creepy.
Is it? No, what?
If somebody was like, I have your face tattooed on my arm.
So the only thing about that.
What if
that
it was my face on some guy's arm?
That was what I was going to say.
Is that okay with you? I do have some raving fans.
Generally, no. But what if it was just like our whole logo and it was like both of us? I'm still uncomfortable with it. All right, so only girls can get permanent tattoos of the husband and wife law team.
I know lawyers are typically pretty jaded because you do this a lot, but have there ever been instances where you or somebody you were in court with as a lawyer got emotional, teared up or cried? Because I'm sure there's certain situations where it's like, oh wow, this is really heartbreaking. I know it's not against any rules, but I mean, how hard is it to compose yourself if you find, oh, this is a really heartbreaking situation?
So it is against rules. It could be unethical and you could have a whole verdict thrown out for trying to inflame the sympathy of the jury. A lawyer is an advocate for their client, but also an officer of the court. So generally, it's not as emotional for the lawyers during testimony. Why? Because we've heard the story repeatedly. We've lived with this client for years. We've been preparing for weeks or months. So the story can be powerful, but if you're tearing up there, it would be unusual, right? Because you know what's coming. You've talked to these witnesses on the plaintiff side, and on the defense side, you know, with the way you're perceiving it, you're unlikely. The first time I ever almost got emotional, I was doing a closing argument for a client. The injuries were bad, and I looked at Hugh. He had probably been our client for 4.5 years. When I looked at Hugh, I was delivering closing. My voice cracked like Sean McDonough in The Trouble with the Snap play. Again, when Michigan State beat Michigan, and I had to compose myself. In that case, my emotion was real. I wasn't expecting it, but if the jury thinks I'm trying to manipulate them, what a great way to kill an entire case. I think it can happen. I don't think it happens often. I mean, you're a professional, you're up there, you know it's gonna happen, but sometimes you're talking about a client, and it's been more than one occasion where I had to consciously go through, you know, try to not show too much emotion no matter how much I feel it.
We had one case where it was the drowning of a little boy, and they had the videotape. Do you remember that? And I just, that was gut-wrenching. But you have to do your best to not show emotion, even if you do have emotion, because otherwise the other side can, like Mark said, say that you're showing too much emotion, and you're not allowed to do that, because then the jury can feel as though
you can be passionate.
Yeah, you can feel passionate.
I think we both bring that. I mean, we have passion, and I deliver at the right time with passion.
Yeah, for
but
sure.
I think that's different than...
You can't cry. Like, if a lawyer was crying and they're delivering their opening or their closing, the judge would probably be like, you can't be on this case. Like, they would literally probably stop.
There was a really famous, successful lawyer in Arizona who would cry during closing, like legendary for a lot of huge cases, but that's highly unusual. It was a much smaller bar then. The judges and lawyers knew each other, and it obviously worked, but generally not a good move anymore.
About how you're still feeling physically and emotionally. And I know that's a big question.
It's a great job by that lawyer saying, I know it's a big question. It sounds like a conversation.
You describe how it is with your left hand still? The things you can and can't do, even to this day?
Funny, I thought her right hand was hurt because her fingers were always down, but it was her left hand. Shows you what I know. Thought I had identified the nerve damage.
Can you tell the jury when we have lunch together, are you able to open your potato chips, or do I open your potato chips for you?
I asked you, we had, we catered sandwiches in a box, and a small bag of chips and cookies were catered, and I was trying to open the bag of chips on my own multiple times. Different ways, trying to hold it different ways, and I eventually asked you to open it. It's the same thing with water bottles. Overall, I would say I do struggle with doing things.
This is why you and I always talk about, you don't try to win a case through your client. On an injury case, you would like everyone else to come up and talk about all the specific things the client cannot do, or the things they can do, but it's harder, so that you don't have to count on the client. First of all, the client has less credibility than anyone else because they're the one talking about it. Second, they're living it. And finally, I want my client, whenever possible, to focus on, in front of the jury, what they do to overcome it, not focusing on the injury. You can see, and I'm not at all critical, I think that this lawyer is leading in the right way. If they object right now, they look like absolute jerks. You can see how much she's struggling. She's doing a good job. She's helping her along. I'm not critical, but you can see why it's so important to not have to have your client who's badly hurt tell the story of them being badly hurt. It's so hard for them to carry the day. It's much easier if others have already carried the day, and by the time the client's up there, you get a feeling for what they go through, but you're not counting on them. And I imagine that's already happened in this trial, just not in some of the things we've seen.
One of the things that I love that experts also do that somebody who's hurt couldn't do is they literally will show demonstrative, a model of a hand, which by the way, we still have that foot model of a case that we were going to trial on. They can go up and show the actual model of the hand and be like, this is connected to that, which is connected to this. And I would expect her to have pain to this degree, and this is why, and this is what will be expected in the future. And this is how many surgeries she may have in the future, or how much medical bills she'll have in the future, or arthritis is going to happen, or what we will expect her not to be able to do in the future. I think having the experts like that are where they can show, especially in the models, are really,
You know what
really
I think?
Cool. What?
You're 13 minutes late to pick
Yeah,
up your
we
son.
gotta go.
Look at this. This is what happens when you work with your wife. Mid-discussion of this crazy trial, super interesting trial, we're going over it. She's like, I gotta go. What do you mean? I'm on my own. So for those who want to log off, now it won't be nearly as good. I'm stuck here by myself, but I'm going to do my best. So let's continue on with this trial and see what we got.
For example, we heard from your sister yesterday, and she described a change in your relationship with not only her, but friends. Are you able to explain a little bit to the jury about how you feel maybe those relationships have been changed?
The best I can explain it, it's like I still feel connected and close, but it's also that feeling of distance, a little numbness.
That's why a written transcript never does
And,
justice
it's like
to what
I
someone
know
says.
I trust the person
You
I'm
can
with.
feel her pain,
You know, I love
not
them,
in
I
her
know them.
words.
But there's something that's just different. I can't necessarily put it into words.
She's looking at the jury.
Can you please state your name for the jury?
Sure, I am Dr. Amy Klinger.
And Dr. Klinger, what do you do for a living?
I am the Director of Programs for the Educator Schools Safety Network.
Your Honor, at this time I would like to offer Dr. Amy Klinger as an expert in the field of education, administration, and school safety to testify regarding professional standards in this case. Dr. Klinger, at my request, have you reviewed documents and information to determine if Dr. Parker failed to exercise any care or breached professional standards related to Ms. Zwerner on January 6, 2023?
Yes, I have.
Okay. What have you reviewed to give your opinions to this jury in this case?
One of the ways that people undermine it, it's actually much harder than it sounds. If you give your expert everything, including things they don't need, then they're spending a lot of money, that's your client's money ultimately, to review a bunch of irrelevant things. On the other hand, if they don't get something, then the other side says, oh, so-and-so didn't provide you that document, so you don't even know what it says. So you don't know if it's relevant to this. Do you have any idea why they didn't provide it? So it's a balancing test because the money does matter.
The discovery materials, both from the plaintiff as well as from the defendant, as well as the forensic services, the witness statements and incident reports. I've also reviewed materials related specifically to Newport News schools in terms of their operations plans, their employee handbooks, those sort of things, both for the district as well as for Rich Neck Elementary. I've also reviewed the depositions, all of the depositions that were taken from the various parties involved. I've reviewed the school records for the student, JT, and then in addition, I've reviewed some additional things in terms of the forensic interviews, some of the circuit court materials for that involve the aspects of the mom.
Okay. Dr. Klinger, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker breached professional standards with respect to Ms. Zwerner on January 6, 2023?
I do.
And what is that opinion?
She did not.
And Dr. Parker, to a reasonable degree of educational and professional probability, do you have any opinion regarding whether Dr. Parker was indifferent to Ms. Zwerner on January 6, 2023?
I do.
And what is that opinion?
She was not.
All right, so let's take it one by one.
Remember when I said earlier, it's all about cross-examination? Let's see how this goes.
You talked about in direct how teachers are first line responders, true?
Teachers and support staff.
First line,
Yes.
which means that there's a second line.
Mm-hmm.
Is that right?
Yes.
Second line being the assistant principal, true?
Well, it depends on the hierarchy of the school. I mean, some schools don't have assistant principals, but if you want to say administration globally, yes.
And in this case, Rich Neck did have an assistant principal, true? And that assistant principal was Dr. Ebony Parker.
Correct.
Let's take it step by step.
Okay.
You agree that an assistant principal can't just sit in their chair and wait for information to come to them, true?
I think that an assistant principal can have a reasonable expectation that if there's something she needs to know, people will tell her.
Okay. And so she should just assume everything's okay unless somebody comes and tells her more.
Well, your option then is that you have to go door to door and ask everybody, hey, is everything okay here? Is there anything I should know? Is there anything? And that's not really feasible for the management of the school.
Really happy you said that, actually. Really happy you said that.
That's improper because he's in effect testifying. He's really happy she said that. But if they object, he's made his point. Now, sometimes the judge will come down on you. Your job is to ask questions, counsel. What's interesting is, at least in that shot, he asked her a question and ended it with correct or true, hoping she'd just give a yes or no. He allowed her to then go off and give her a little explanation. Tough choices, right? If you then start cutting her off, which you can do, you look scared. On the other hand, if you don't do that, you lose control of the witness. So these are things that are happening in the moment, not necessarily a right or wrong decision, but critical decisions for your control of the witness.
At noon, around noon, did Ms. Kovac go into Dr. Ebony Parker's office and report that students were saying that JT had a gun in his book bag?
My understanding in the review of the materials is that she said that the students reported he had a weapon.
And so when you said earlier, you can't go around every classroom, knocking on every door, searching every bag. You recall that testimony?
Well, I was speaking in terms, your question was about finding out if everything was
I think
okay.
she seems
It wasn't
evasive.
about searching bags.
Okay. Well, in this case, there was a specific child reported to have had a gun in his book bag. True?
What?
Yes.
Ooh,
And
she agreed.
Because communication is a two-way street and getting in good information is a two-way street, you would expect the assistant principal to attempt to get some information herself. True?
Well, according to that statement and the materials that I read, there was a discussion between Ms. Kovac, who was a seasoned educator with a relationship with the student, third in line in the chain of command. There was a discussion between her and Dr. Parker, and Ms. Kovac indicated she was going to go and look in the book bag.
And based upon the information that you received, that she checked the book bag, there was nothing in the book bag, but that there was a report that there was something put in his pocket. True?
That was a report made later, yes.
Such an interesting thing. First of all, she said it was a weapon because that was important to her, as if it matters. You hear a kid has a weapon, but it's not a gun, you're still probably gotta have to go check it. But what was interesting is she later agrees it's a gun. Now here it left off where she was like, the assistant principal was told that this other person, who they disagree if she's the third in command or not, because the assistant principal was there, she says, oh, I'm gonna go check the bag. Wait, if I'm the assistant principal and you say I'm gonna go check to make sure the bag is safe, then do I have to get up? Now, we didn't see the rest of that testimony, but that was a fun moment of cross. This is the hardest moment.
Will you please read the verdict?
This is the toughest moment of
We,
trial.
the jury, on the issues joined, find in favor of the plaintiff, Abigail Zwerner, and assess her damages at $10 million. The award interest beginning on June 1st, 2024.
Thank you, counsel. Any requests from the plaintiff? Any requests from the defense?
That we schedule time for post-trial motions.
All right.
And
All
would not be entered on the verdict today.
all right.
What can happen there sometimes is you pull the jury. If you win, you probably don't want to pull the jury. Pull the jury means, Judge, I know that's what the foreperson said. Look who showed up in the last 30 seconds. Hello, Alexis. Hello, how are you?
Hi, Mark.
We just got a verdict for $10 million against the defendant for the plaintiff.
Yes.
Yeah, it wasn't us. So anyway, is there anything you'd like to add now that you've come back to take me to go get this car and after abandoning me?
I had an awesome Reese's peanut butter cup.
Great. You're sitting, but we're late. They're going to close this place. What time is it? 548. Oh, hey, what's up, Brez? This is our killer attack dog.
This is our killer attack dog.
Did you already get the car?
No.
Then we gotta go. I would love to know how she doesn't think we're in a hurry. Anyway, the plaintiff's lawyers, from what I saw, did a great job. We didn't see enough of defense counsel to have a strong opinion, but I'll say overall, this looked like good lawyering on both sides. Like, I don't always say that. Sometimes I have to kind of beat around the bush. I don't want to attack anybody, but I really like what the plaintiff's counsel did from everything we saw. And there was nothing defense counsel did that made me go, you gotta be kidding. You know, I think that ultimately, what does this case come down to? It probably came down to a lot of frustration and anger that there's a school there that can make choices to make sure this never happens, and they failed to do it. $10 million says that they were not a little motivated, they were extremely motivated because of the size of that verdict. Look, right here, this is a video YouTube's like, yo, check this video out. Don't forget to comment, subscribe, like, follow, do all the things, and let us know what did you like, what did you not like, what else would you like us to comment on. Not a lot of real trial lawyers that are out here on YouTube trying to explain some things, so let me know what you like. Thank you very much for hanging out with us.